Well, hello ladies and gentlemen, I'm Philip Harris. I'm a partner in the construction team at Wright Hassall, and this is yet another in our series of Law Bites takeaways where we're doing a bit of virtual training post-COVID. And I'm talking today, my topic for today is risk in the ground, the legal aspects. So this vlog is a guide and a reminder on how risk in the ground conditions is dealt with in construction law and building and engineering contracts. Basically, it's aimed at contractors and employers under those contracts, but it's also going to be relevant to surveyors, engineers and architects. So the theme is the risk in the ground, the common law principles that would apply irrespective of the contract. The common law principles are that the employer generally does not promise or warrant the accuracy of the site and soils surveys. Instead, the risk in the ground rests on the contractor. This is the position under building contracts. So the employer comes along and he says, these are the surveys I've come up with, but I'm not promising they are correct. It's for you to find out. And to emphasise that, if we go to Halsbury's Laws of England, the basic traditional ancient laws of England, I'm going to quote from an earlier edition, but this principle still applies now. It's no excuse for the non-performance of a contract to build a house or construct works on a particular site that the soil has a latent, in other words hidden, or patent, in other words obvious, defect rendering building impossible. It's the duty of the contractor before tendering to ascertain that it is practicable to execute the work. So that's from the second edition. So the contractor must complete the job irrespective of the ground conditions, and even if it takes him to insolvency. There has been an example, is a case where they were working to construct a coffer dam alongside the bank of a river, and the bank kept falling in, and the judge was apparently unsympathetic, and he said, no, despite those circumstances, you promised to do this job, you must see it through, you must take yourself to insolvency in order to fulfil your promise. So, as I say, if the employer merely presents the contractor with the surveys obtained in good faith, he's not promising that they're correct. Now, there are a series of situations where the contractor may have some comeback, he may have some rights of claim. So let's just run through some of these as sort of exceptions. So one would be a misrepresentation from the employer about the site and soils conditions. Now there are different kinds of misrepresentation, fraudulent, negligent, innocent, and they carry different remedies. But if there is a misrepresentation, you may be able to have the contract set aside or claim damages, financial compensation, or both, depending on the kind of misrepresentation. Then there is deliberate concealment of a fraudulent nature, which, as you might expect, fraud will allow you to void the contract, you may be able to claim damages for fraud. And exceptionally, and we'll come on to look at this, an employer does, in all the circumstances, warrant or promise the accuracy of the site or soils information. And then, as regards professionals, from the contractor's point of view, if he is in a close relationship akin to contract with a professional like an engineer, and that engineer makes a misstatement, then the contractor may be able to claim money, financial compensation from that professional, or of course if the professional is novated, so he starts off working for the employer and then the engineer gets novated, passed over in a three-way contract, it's passed over to the contractor, then he's deemed to have worked from the contract for the contractor from the very beginning, and in that situation the contractor would have a claim against the professional. But to go back and emphasise the basic rule, Hudson's Building and Engineering Contracts 13th edition says, "A great weight of authority exists, showing that an employer, in the absence of an actionable misrepresentation or deliberate concealment or some express warranty, owes no implied duty to the contractor, whether of disclosure or otherwise, in contract or in tort," so in contract or in negligence outside of contract, "with regard to the pre-existing state of the site. An employer is under no duty to do work to render the site easier to work on, or to conduct surveys or sink boreholes or make other investigations. An employer may suspect that the contractor has underestimated the difficulties, but is under no duty to warn in the absence of fraud or deliberate concealment." So he doesn't even have to warn, even though he suspects the contractor has underestimated what needs to be done. And then we come on to this vague area of, well, can there be a warranty from the employer to the contractor, a promise about the site and source conditions? And yes, there can be. There can be what's called an express warranty. So if a contractor can show that although a statement is not in the contract itself, nevertheless there was a promise in the background by the employer, that's regarded as a collateral warranty, a side promise, and the contractor can then recover damages for breach of warranty. So if you looked at all the circumstances, the nexus, as lawyers say, and you found such a promise, then there would be an express promise and you could rely on it. A warranty must be strictly proved, so it's going to be very difficult to show that that promise existed, even though it's not apparent from the contract. And then there are implied warranties, and the best way to give you an example of an implied promise or warranty is the case of Bacal, B-A-C-A-L, Construction Midlands against Northampton Developments Corporation. So the contractor was instructed by the employer ultimately to design foundations on certain assumptions as to the ground conditions. So what seems to have happened was that the quantity surveyor in the end sort of got tired of the contractor asking questions and said, "You are to assume that the ground is sound." So it was, "You are to assume," and there were soft spots in the ground, not what was they were required to assume. So the court said there's an implied warranty that the ground would meet the assumptions the contractor had been directed to make. So if you reverse the normal rule, instead of saying, "Look, I assume based on the surveys I've got that it's good ground, but you are to find out," if you reverse that and say "you are to assume," then there's an implied warranty and the contractor can rely on it. Then we need to bear in mind, very importantly, that building law contracts and civil engineering contracts have sort of bifurcated. They've gone their separate ways over the years. As a broad generalisation, under building contracts, risk in the ground more extensively falls on the contractor. He is responsible for the how of the process, for the temporary works, for getting on with it. And in building contracts, traditionally, the professional team, the architect engineer, is responsible for the design of the permanent works, and they're not responsible for the temporary works and the how of getting on with it. Now obviously things have become more muddy, more murky in recent years, and you do have engineers who specifically hold themselves out as temporary works engineers. But in building, the normal position is that the contractor is responsible for the how, and so for the ground conditions. In civil engineering contracts, it's much softer on the civil engineering contractor. It's always been understood that professionals may roll their sleeves up and get involved in the how. They may give directions as to bag work in a live ditch or something like that. So let's look at NEC 3. There's a compensation event, 60.1 subparagraph 12, that the contractor encounters physical conditions which are within the site, are not weather conditions, and an experienced contractor would have judged at the contract date, so at the time the contract was made, to have such small chance of occurring that it would have been unreasonable to have allowed for them. So if you can show that you didn't allow for these conditions, but any experienced contractor at the time that the contract was made wouldn't have allowed for these conditions, then you are off the hook, and that is a compensation event, and that will probably carry an extension of time, and will probably carry some money in compensation with it. Going back then to the JCT contracts, the standard building contracts, there is one situation where the contractor may be off the hook in relation to the ground conditions, and that is where there are bills of quantities, and those bills are required to be done under the standard method of measurement, now the RICS new rules of measurement. And then the standard building contract 2016 at 2.14.1 and 2.14.2 says that where the contract bills are to be prepared in accordance with the measurement rules, and there is an unstated departure from the method required, or error in description or quantity, that is corrected as a variation. So if in preparing the bills they didn't follow the measurement rules, or they got the quantities wrong, or made an error in description, that's a lifeline and a safety net for the contractor, because that then becomes a variation. And so, for example, if the description or quantity of earthworks support is wrong, or a generic description of rock is incorrect, that would be a variation, and that would carry with it both time, and so an entitlement to additional prelims, and an appropriate change in price, and maybe loss in expense as well. So something else we need to consider is rights of support. If you're going to dig a big hole, if you're excavating, if you're working in the ground, you need to consider the rights of support. And that is the rights of support from neighbouring buildings, the building next to it, and from the neighbouring land. People don't realise this, but there's no natural right of support of a building, not in law. But if the two buildings have been smack up against each other for 20 years, then after 20 years you get a right of support. Or if there were two buildings, like two halves of a semi, and they were in common ownership and one is sold, then the buyer would normally acquire a right of support from the other property. That's buildings. Land is different. Land may have a right of support from adjacent land, so you're higher up the slope, neighbours lower down the slope, you've got a right of support from his lower land. And if removed, the contractor and the employer, the people who've done that, may be liable to the neighbour, but there must be physical damage for you to make a claim. But having said that, there is something called a Timids injunction, which means I fear, so that if it's pretty obvious, you can see that they're about to do something disastrous in moving your support, you may be able to get an injunction to restrain that. And then thumbnail sketch here, but consider the Party Wall etc. Act 1996. So even if you're digging on your own land, or you're a contractor and you're digging on the employer's own land, if you're digging within 3 metres or 6 metres, you fall within the 3 metre or 6 metre rules under the Act, you may have to serve notice, and if you don't serve notice under the 3 metre or 6 metre rules, where you're going to a greater depth than the neighbour's foundations, then you could be in a lot of trouble. So bear in mind the requirement to serve notices under the Act. And finally, we'll just talk for a moment about professionals. And the professional hearing this may say, well, I'm off the hook. I'm not responsible for the design of the temporary works or the how of the process. But look at your position relative to your employer, the person who's employing you. A professional can be liable to his employer and, as I've said, liable to the contractor if he's novated over to the contractor. And to emphasise this, Hudson's Building and Engineering Contracts again says, a necessary preliminary to a successful constructional design must in nearly all cases be a sufficient examination of the site, so this is the professional, a sufficient examination of the site with a view to determining the plan area available for the proposed works and the nature of the subsoil with a view to deciding on the correct design for foundations or methods of underground working. And they go on to say that an architect or engineer who does not make a personal visit to site or, and there is an or here, check carefully the surveys will be at considerable risk. So from a professional's point of view as well, you have to do these steps and take the risk in the ground seriously. So that's a very brief overview of risk in the ground. Yes, so as the BBC says, if you've been affected by anything in this production, please do contact us at Wright Hassall. You can get in touch with me. Go on the website, you'll find my details, I tend to deal with the contentious side of matters. On the non-contentious side, drafting contracts, speak to my colleague Mike Hiscock, who is a partner and the head of the team. Thank you very much.